it will be in a method different from what in previous classes I have been taking. Case laws, it will be from my prior certain notes along with the regulations and rules. So can any one of you, one second, can any one of you explain what is a control? I believe all of you have read the Companies Act. Okay. I'm sharing one page. I'm sharing the Competition Act, but you have to tell what is a control. Can anyone? See, it has to be, you have to communicate. Okay, I don't want silent spectators. Okay, boss. Any one of you? Mr. Vipul Kumar, you were there in the previous class. Nikunj, you were there. Venkat Krishna, you have joined for the first time.
Yes, I was in the previous class.
So tell me, what is a control?
Sir, control as a term.
Basic terms as defined in the Companies Act.
Control has been defined in the Companies Act 2013. So control is basically in the company is to appoint directors or affect the management decisions of the board directly and indirectly.
Okay. Now what today I have changed the pattern. I'll take you to my notes directly, and it has case laws. So you have to read it from there only. Okay. Can everyone see control under merger control laws? Yes or no?
Yes, sir.
Nikunj, Vipul Kumar? Yes or no?
Sir. Yes, sir.
All of you, Venkatesh, Dr. Mustafa?
Yes, sir, I'm seeing it.
Oh, good. I can hear you now. So under Competition Act, control is defined under explanation A, section 5A of the Competition Act, as control includes controlling the affairs, okay, controlling the affairs or management by one or more enterprise, either jointly or singly over another enterprise or group, okay, one or more group, either jointly or over another group. So control is basically controlling the affairs and management by whom? By an enterprise over another enterprise, or by one group over another group. Clear?
Yes, sir.
Therefore, definition of control under Competition Act is not only inclusive in nature but purposive in nature, as combination is not only acquisition of shares, voting rights, assets, but also acquisition of control by the acquirer in the target enterprise. Remember when we read section 5, the word control was there, 5A, B, C, right?
Yes, sir.
The commission has passed several orders where it has discussed sole control, joint control, negative control, positive control, which resulted in acquisition of control. Okay. Okay.
Yes, sir.
Now, sole control means it confers right on single entity to determine strategic decisions in an enterprise. What do you mean by strategic decisions? I have already taken that class of schedule 1. Can anyone explain to me what is a strategic decision? Whatever comes to your mind, please speak.
Any decision-making process which impact the company.
Yes, but you are far off from the correct answer. Dr. Mustafa. It's a common sense. Strategic decision. Let me give you a hint. Decision which is strategic in nature is known as strategic decision. So what kind of decisions can be strategic decisions? Any one of you, Dr. Mustafa? Okay,
Kind of decisions which require majority.
somehow, but not correct.
Not correct.
See, strategic decisions, there are certain list of matters for which the acquirer also wants its say over it. So it creates veto rights. Those strategic decision can be change in MOA, this change in charter documents. I believe you understand charter documents.
Yes, sir.
Charter documents, or some change in the management, or a new business player, okay, or a new shareholder, bringing in new shareholder, or some kind of PE investment or something kind of those nature which are strategic for the business. Okay, joint control is footnote, and it is classified as possibility of a deadlock situation where resulting from the power of two or more enterprise to reject the proposed strategic commercial decision. Okay, then we have negative control and positive control. This is very important. See, before we go, what is negative and positive control? Initially, when CCI started vetting merger control, it only looked into positive control. Now it looks into all kinds of control: positive control, negative control, joint control, sole control, de jure, de facto control, everything. So it has expanded its bandwidth. Okay. So positive control are generally participatory in nature, such as participating in day-to-day working of a company. Negative control means an investor protection right in nature, such as veto rights, appointment of observer, appointment of chairperson, right? Understood?
Yes, sir.
Further, acquisition of control test. Basically, acquisition of control. Whether what is an acquisition of control test? Can somebody tell me, explain to me? Without reading what is there, I'll explain it to you. Please. See, when a acquirer is acquiring a control in another company, that is known as acquisition of control test. You have to examine. Okay, is a factor determining whether two or more entities qualify as a group. Okay, as concept of group is linked into control. So basically, if you have to check whether the acquirer is acquiring control or not, you don't have to look into the section 5A explanation A. You have to look into B also. B speaks of basically group. Okay, now I'll take you to Combination Act, Competition Act. I'll take you to the act now. Oh. A, everybody understood? Okay, one second, it is down. Yeah, explanation. Everybody understood this portion? Wait, once. Everybody understood control? What is control? Yes or no?
Yes, sir.
You don't have to be silent spectator, boss. It irritates me a lot. See, there's a difference. Now B is group. Here the word is inclusive. Here the word means whatever is written here is only group, nothing more. Includes means more than what is present here. Okay. So group means two or more enterprises which directly or indirectly in a position to exercise 26% or more of voting rights over other enterprise, appoint more than 50% of members of board of directors in other, control the management or affairs of the enterprise. So basically 1 or 2 is very easy. Okay, you are earlier it is written as 26%, but in one of the notification it has said 50%. So you don't have to look into group companies where the parent entity is holding less than 50%. Okay, appoint more than 50% board of directors. Okay, in those group companies, parent entity. Okay, control the management. So 1 and 2 are simple. Are everyone able to understand?
Yes, sir.
Now, what is this control the management or affairs of the other enterprise? That we will look in here. Okay. So in order to qualify as a group, first test is to determine that the entity is an enterprise, okay, or not, as defined in the Competition Act. Okay, it has to be an enterprise. Second test to determine whether two or more enterprises, directly or indirectly, in a position to exercise minimum 50% voting rights in other enterprise, or holds more than 50% board of directors, or has the ability to control the management or affairs of the group of the other enterprise. Right? Any problem to anyone in
No.
understanding?
No.
I want to hear from Dr. Mustafa and Venkatesh also.
Yes, sir. Clear, sir. Fine, sir. Fine.
Fine. Venkatesh, Venkat Krishna, Mr. Venkat Krishnan, are you there or not? Mr. Venkat Krishna. If you are unable to hear course anchor, please look into it. Okay. Okay. Now we look into the second test. Okay. Has the ability to control or the affairs of management. Thus, there are three parts to second test. What is the first test? First, it has to be an entity. Second, it has to be either one of these three. So there are three parts to second test, which are ability to exercise voting rights in other enterprise. Okay, now we look into de jure and de facto. What is the de jure and de facto? Okay, footnote 13. 13 means de jure control where shareholders confer more than 50% voting rights in the other enterprise. Okay. De facto means hold more than 50% of voting rights. Okay. But does not hold more than 50% of voting rights, but control the more than half of the votes in the board meeting. Understood? Yes or no?
Yes, sir.
Yes,
Please,
sir.
guys. Only few students are there and still you guys don't speak up, huh? So ability to exercise voting rights in other enterprise, ability to appoint majority of board of directors. Okay, de jure and de facto. Ability to control the management and affairs of the other enterprise. So it is observed that only one of the three parts of second test is sufficient to determine group error. However, the first two parts of the second test are simple and straightforward, while third part is tricky, which is determinative of acquisition of control. Okay, now we have to understand what is this ability to control the management and affairs of the other enterprise. Okay, so this part of the second test is linked to degree of subjectivity of control, and therefore it is pertinent. This is very important. See, whenever you have to determine control, 90% of the times you have to look into this only. Ability to control the management and affairs of the other enterprise. Okay. Rest of the time, it will be a very straightforward or simple. Okay. So this part of second test is linked to degree of subjectivity of control, and therefore it is pertinent to examine whether an enterprise has the ability to control the management and affairs of other enterprise in order to determine whether two or more enterprise belong to same group. Okay. Now, how do you determine this ability to control the management and affairs of the other enterprise? Any idea?
No.
Any idea? So how will you determine? Through the test of influence. What is the influence acquirer is trying to have over the target company? Decisive influence is positive control. Okay. Material influence is negative control. Significant influence is somewhere between decisive and material, or competitively significant influence of other enterprise. Okay.
Yes, sir.
Okay. Now this is important. So the Competition Act says that if anything which is not defined in the act or regulations or by the CCI in its order or in any notification of the MCA, you have to look back into your parent act. Parent act is Companies Act. So here we'll see what is basically control. Means any word or expression not defined in the act and defined in Companies Act shall have the same meaning respectively given to them. Okay, accordingly to determine control under Competition Act. One shall also refer to statutory interpretation of control as per Companies Act, where certain equity caps on shareholding reflect the level of ownership or control exercised by the acquirer. A shareholder greater than 25% has a right to block special resolution. A shareholder approximately 49% level of control short of ownership is a level of control to represent a level of control short of ownership. What is the what percent of shares are required in a company to own a ownership? Anyone? Just give me 1 minute. Any you answer this question? Just give me 1 minute meanwhile. Yeah. So what is the share percentage of share required to own a you want to own a company?
More than 50%.
So shareholding approximately 49%. Equity share represents level of control just short of ownership. Shareholding approximately 50% signifies ownership and a right to pass ordinary ownership. Shareholding over 75%, the entity acting in unison can pass a special resolution. Okay, got it? Yes or no? Any difficulty?
Yes, sir, understood.
Okay. Now, why does CCI look into control? Common sense. I've told you these things previously. Why does CCI look into any transaction? Why? Anyone?
Because
Anyone?
it affects the market.
Sorry?
It affects the market and the consumer.
Correct, but not the exact words which I'm looking for. Mr. Mustafa.
So because it can affect the decision-making process of the company.
No. See, the competition dynamics is something. Competition dynamics is a word which has evolved. What if there is fair competition in the market? Okay, and certain transaction can result in anti-competitive behavior. To prevent those anti-competitive behavior, it examines those transactions. And how does it examine? It has defined certain parameters. Those parameters have trickled down in terms of acts, regulation, decisional practices, notifications. So here, CCI examines acquisition of control as combination of, as combination of previously independent assets, which is likely to material. This is very important. This is very important for understand this line. The CCI examines acquisition of control as combination of previously independent asset that is likely to materially change incentives. Okay, what incentives? Incentive to compete, how the asset shall be used in a competitive process. Okay, this view of CCI on acquisition of control is very different from the views of other sectors, regulators and legislation. Okay, so the concept of control has been defined differently under Companies Act, under Takeover Code, under FDI regulations, under insurance laws. It is different. Why it is different? Because each has a different parameters and substance to meet. They're different laws. Okay.
Yes, sir.
Having stated this, the Commission strikes a balance between need to notify a transaction that are sufficiently material and may harm competition process through more durable changes in the marketplace and need to keep the process manageable and predictable. How many of you understood this sentence? Read it on your own. Having said this, read it. Read it, boss. Have you read it? Dr. Mustafa,
Yes, sir. Ravi.
did you understand what this highlighted sentence is? Having stated that the commission strikes a balance between need to notify transaction data sufficiently material and may harm the competition process through a durable changes in the marketplace and the need to keep the process manageable and predictable.
No, sir.
See, at times there are transactions where CCI has to interfere because that may result in a competitive harm. Okay. And result in the changes in the market dynamics. What are market dynamics? Market shares of party. Some may become a dominant entity. Okay. Some may, an entity may completely move out of the market or there will be a full foreclosure. But at the same time, it has to look into those transactions which are not causing any competitive harm. Okay, those transactions it doesn't look into. Okay, the Competition Act provides with, okay, now I'll go to decisional practice directly. 1 second. The commission has resolved concept of acquisition of control through its decisional orders, and it is most debatable issue among the corporate sector in India over a decade. The spectrum of control as captured by the commission range from purely financial investment. What is meant by purely financial investment? I have already covered in Schedule 1. Anyone? Nikunj and
Sir, there
Purely
will
an
be
investment. Na.
sorry.
Purely an investment purpose.
So, and what more? Correct, you are correct. So, range means it used to only look at financial investment. Now it looks into ability to shape firm decision. Now it further went to ability to have decisive influence in control, and it also looking at majority acquisition. Okay.
Hello.
So, I have already shared.
कौन किया था?
Sorry.
Chinese bowl.
Sorry.
औरत आएगा तो मेरे को बोलो अभिषेक निकलने के बाद.
Please mute yourself.
हो गए, निकल गए वो लोग. गए वो लोग.
Force anchor, please look into it. Okay. So I have already shared the case laws with you. So the first was Century Tokyo Leasing Corporation. Okay. And Tata Capital Financial Services Limited. Okay. So it considered the approval of business plan, including the budget. Here, basically the acquirer approved the business plan. It said that if any business plan is required, including budget, discontinuation of existing or commercial new line of business, setting up new offices in other cities, expanding to the appointment and removal of directors, appointment of key managerial person, including key terms, material terms to employee benefits. Okay, all these will be list of rights which will be exercised through veto right. So commission defined if in any transaction, if the transaction document contains these things, that is a test for acquisition of control via degree of joint control both the acquirer and the target will have over the asset as well as leasing business. Similarly, then there is this SPE holding MSM in India, and which has strategic commercial operations, hiring, termination of key managerial persons, engaging in new line of business. Okay, if both the acquirer and the target are saying that the target cannot hire or terminate KMP on their own, they require the consent of the acquirer also. So these will be listed in a list of matters, and veto right means that even if the target has the ability to approve certain matters on its own, certain matters can only be approved with the approval of the acquirer. Understood? This is a very important sentence which I said. Yes or no?
Yes, sir.
Okay. So say now Nikunj, I'll give you an example. Say Nikunj is the target, owns the target company, and it is saying that the same similar case. Okay, it is saying that I want to appoint new key managerial person after this acquisition. Now Dr. Mustafa is the acquirer. Now he has list of matters over which his rights are also required. Those are known as veto rights. Now Nikunj has the ability to approve certain execution of certain matters on its own due to the shareholding structuring, due to the shareholding and structuring of the transaction. So can Nikunj on its own appoint key manager, new key managerial person? Yes or no?
So here, if they have veto, they even if I try to appoint, they can veto the decision.
Yeah, correct. But I want yes.
Yes, so the answer will be no.
Okay. Vipul Kumar. Will the answer be yes or no? Nikunj has a power and ability to appoint KMP. However, Dr. Mustafa, during his investment in Nikunj company, has said, look, boss, I want a list of certain matters over which I have rights. And even though you have power to execute certain matters, okay, but with certain list of matters mentioned, you need to take my approval. So can Nikunj, does Nikunj require approval, veto of Mr. Dr. Mustafa? Yes or no?
Yes, sir.
Okay. Now we take into the third case. Then there is this case of Alpha TC Holding. Here also, what happened? Here negative control was discussed. That was positive control. Here it is negative control. Negative rights amount to acquisition of control, such as amendment of charter document, approval, adoption, amendment, modification of annual business plan, annual budget plan, annual appointment or removal of KMP. Further, the commission opined that the quorum of board meeting required the presence of at least one acquirer director to discuss reserve matters. Okay, at the board level, it is observed that reserve matter for which consent of acquirer is required include strategic commercial decision of target, and the same therefore cannot be considered as mere minority protection decisions. Okay, so let's go into this footnote 18. Everybody there?
Yes, sir.
Okay, reserve matters include amendment to charter document, change in the capital structure, including through a new issues of equity, buyback, rights issue, bonus, stock split, sweat equity management, appointment or removal of any member of senior management, reorganization or change in the nature of current business or launch of any new business, appointment or removal, appointment or removal of a nominee director, appointment of every corporate representation for attending meetings. Okay, if these are certain examples of reserve matters. Okay, understood?
Yes, sir.
Yes or no, boss?
Yes.
So we have taken two cases on positive control, one case of negative control. Now this case, Itihad one, is very important because that ability to exercise, okay, that point 3, ability to exercise is defined here. Okay, in Jet Itihad, CCI held that Itihad neither had the voting rights. Remember that nor ability to control the board of directors of Jet. Okay, remember that section explanation B, section 5 explanation 5B. Remember? Yes or no?
Yes, sir.
Okay. Now Etihad neither had requisite voting rights nor ability to control the board of directors of Jet. So how will you exercise that it as a control? Yet it was possible to infer control by virtue of ability to control and manage the affairs of Jet through commercial cooperation agreement. So you have to look into all these agreements. Understood?
Yes, sir.
Why am I only hearing only one person? There are other persons. Dr. Mustafa, you are there or not?
Yes, sir, I'm hearing.
So
It's fine.
you understand this is a very important case, first of
Yes,
its
sir.
kind. Okay. So
Yes, sir.
it did not have any voting rights or did not appoint its director on the board of Jet, but still it was controlling. How? Ability to control and manage the affairs of Jet through commercial cooperation agreement. Under the CCA, the parties had agreed that they would frame cooperative procedure in joint route, schedule coordination, joint route and schedule coordination, joint pricing. The parties intend to establish center of excellence either in India or either in India or
In Abu Dhabi. Abu Dhabi.
India. Etihad would recommend candidates for senior management. Okay, management control the affairs, control and manage the affairs. Jet would use Abu Dhabi as an exclusive hub for scheduled services. Okay. 1 second. From Africa, North, South America, UAE, Jet would refrain from entering into code sharing agreement with any other airline. Okay, which has the effect of bypassing Abu Dhabi as a hub for traffic and to and from the above said locations, or is detrimental to the cooperation contemplated by the said agreement. Hence, the acquisition of control, okay, was through governance structure. Please understand this sentence properly. Why am I? Okay, please understand this. Through governance structure, more particularly through assets and operations of Jet, which is considered as significant. Okay. In terms of Etihad's ability to participate in managerial affairs of Jet. Did you understand? Any difficulty? Hello guys, I'm not talking to the computer, I'm speaking to you guys.
No difficulty, sir.
Yes or no?
Yes, sir.
Fine, sir. Fine, sir.
Okay. So acquisition of control through governance structure. See, governance structure, what it means? Through its agreements. Okay. More particularly over assets and operation of Jet, which is considered as significant in terms of Etihad ability to participate in the managerial affairs of the Jet. Okay, let me go next. Now this is one more case. So what we did, till now, what we have discussed: positive control, negative control, ability to exercise, okay, exercise control over the management, right? Right?
Yes,
Yes,
sir.
sir.
In the 4 cases. Now this is the 5th case. The commission in independent media matter recognized decisive influence. Another this is case as acquisition. It was observed in the event of conversion. How many of you understand optionally convertible debentures? How many of you understand it? Say yes or no. Bolo yaar, don't consume time because I have to take up many things.
It means the debentures can be converted into
I'm hearing a new voice.
normal shares.
Who is this? Venkat Krishna.
Yes, sir.
Good. And to add to your sentence, after a certain period of time. right?
Yes, sir. Yes, sir. Thank you.
Hmm.
Thank you, sir. Yes, sir.
So in the event of conversion of optionally convertible debentures, independent media trust would hold more than 99%. 1 second, where is the 99% of the fully diluted equity share capital of each of the target companies. Hence, the acquisition of such a right to convert the optionally convertible debentures into equity shares confers on independent media trust the ability to exercise decisive influence over the management and affairs of the target enterprise. Okay? Yes or no? Mr. Venkat?
Yes, sir.
So once those optionally converted shares are converted into equity shares, will it have control?
Control over.
Control over the target.
Yes, sir.
Yes or
Still,
no?
it will have control over.
Good. Hence, the acquisition of such right to convert optionally convertible debentures into equity shares confers on independent media trust the ability to exercise decisive influence over the management. Since control over the target company is being acquired by an independent media trust, the subscription of optionally convertible debenture would result into indirect acquisition of control over network TV18. Now, I take another case. LIC IDBI, okay, which speaks of de jure control. Here, LIC acquired controlling stake, 51% shareholder, along with its management right into IDBI. This amounted to outright control of LIC in IDBI, resulting not only in de jure control, but IDBI became subsidiary of LIC. Understood?
Yes, sir.
Now this is Aviva International. Here, there was no change in control over the target on account of proposed acquisition of additional shares by the acquirer from the existing joint venture partner. Hence, the proposed combination was not likely to cause competitive, likely or to alter the competitive landscape in LIC. See, initially I discussed, initially I discussed that CCI has this discretion to look into whether there is change in control or change in competition dynamics. We are dealing with this here in this case. Now, this case, JP Associates Limited, Ultratech Limited, JP Associates Limited, this has changed the complete ball game of CCI. Now, this has given a complete bandwidth to CCI to examine any kind of case where control is involved, whether it is passive control, active control, negative control, positive control, material control, everything. Initially, this case was criticized, but then India is one of the jurisdictions where you look into positive control, also negative control, everything. So it falls into everything. The commission considered shareholding, special rights, status, and expertise of a person, board representation, structural financials arrangement, other rights of acquisition as acquisition of control. So even though there are certain rights which do not amount to control, they also considered as control because they are negative control. In this case, the commission found Ultratech failed to furnish details of shareholding of Kumarak Mangalam Birla and his family members and the companies owned and controlled by them in Century Textiles industry and Kesoram Industries. Okay, as both these companies compete with Jay Prakash Associates Limited. So basically, you are acquiring a target which is a competitor. Okay. Okay. Yes or no?
Yes, sir.
Hence, due to presence of Mr. Birla on the board of Century, there is likelihood of material influence of Mr. Birla over Century and competition distortion from access to competitive sensitive information cannot be ruled out. Correct? Say yes or no, boss.
Yes, sir.
Okay. Now, therefore, to extend that Komaramangala Birla had seats on both Century and Ultratrek board of directors and had chaired 4 of Century's out of 20 board meetings. Hence, Komaramangala Birla has the ability to exercise material influence over Century's affair. The CCI noted that Komaramangala Birla and his family had strategic control holding in Kesoram Century, which conferred them with negative control over both these companies. Understood? Mr. Venkat Krishna, understood?
Sir? Yes, sir.
Okay. Therefore, such shareholding was not solely as an investment or in the ordinary course of business, and the commercial realities are more telling than in the formal agreement and structures. Okay. This was basically about the control. Now, I will, as discussed in the previous class, I'll take you, one second. I'll take you to the combination regulations, and you have to read those particular regulations to understand that what we are, dealing with. Okay. Okay. Everybody can see? Yes or no? I am not speaking to a machine, guys.
Yes, sir. We can see the screen.
Okay. So you read the definition. What is a combination? Okay. Remember, combination means the proposed combination, means the transaction which you are carrying on, or a combined entity means you are close the transaction, or and if the CCI wants to examine this transaction, okay, they have evaded filing. So as per Gun-Jepping, let's penalize them. Understood? The difference between proposed combination and combined entity?
Yes, sir.
Rest are easy. Enterprise means enterprise as defined under the Act. Okay. Now, regulation 4, the schedule 1. Okay, it draws its power from here. Form. Okay. Okay. Form 1 and Form 2. Where did it go? One second. I missed out something. Yeah. Okay. 4, I was here. Regulation form. So there are Form 1 is a short form. Form 2 is a long form. So the recent amendment, now you have to pay a fees of 20 lakhs for Form 1, 65 lakhs for Form 2. Okay. Now, when will you file Form 2? If in horizontal overlap, the combined market share, okay, of the acquirer and target is more than 15%, then you will file Form 2. Okay, when there is a vertical overlap, and if the combined market share is more than 25%, okay. Boss, say yes or no. Did you understand or not? Where is everyone, boss?
Yes, sir. Good.
Now, if you require some additional information, okay, if the commission requires additional information, so it may furnish without a show cause notice here. Okay, regulation 5(4). Okay, go down. Now, if you have filed Form 1 and when the CCI vets your transaction document, it is found that you should have filed Form 2. So CCI requires the information in Form 2 to form its prima facie opinion whether AAC will be caused or not within the relevant shed direct. Therefore, the notice should be filed in Form 2. Okay. So the difference in filing fee, say initially you paid 20 lakhs, now you want to pay, whether you will pay 65 lakhs or 45 lakhs, Mr. Venkat.
Sir,
Initially, if you filed form 1, where the filing fee was 20 lakhs, okay, for a filing fee for form 2 is 65 lakh. Now you go to CCI. CCI said, look boss, this we have to file this in form 2. So will you pay 65 lakhs or 65 lakhs minus 20 lakhs, that is 45 lakhs.
45 lakhs.
65 minus 20, sir.
Okay, great. So if any data is not available, see what happens, these are all commercial transactions and there are many industry sensitive information which CCI wants it. So, and 1, 2, there are certain information which is even difficult for the parties to extract. So it will say that at the time of filing, certain information was not there, which it can file later submit. Okay. Now, what happens when these transactions take place? Board approval happens, and board approval gives authorization. Okay, so it can authorize any of these persons. Okay, sorry, not here. Okay, now other document. Other document means binding document. Okay. Okay. Now, how many of you are aware of hostile acquisition? Have you ever dealt with hostile acquisition?
Yes, sir.
Who?
Hostile acquisition happens when the other party actually doesn't want the person who has got the ownership control to take over, but somehow he has acquired majority shares, at least the controlling stakes, to get in control of the target company. That makes
Go ahead. I'm listening to you, Mr. Venkat Krishna.
that makes it for the original holder of the company, the shareholder of the original controller of the company. In view of them, this the newly acquired the newly acquired stakeholder is a hostile takeover, has committed an hostile takeover.
Okay, so now there can be situation. Now CCI wants information from both acquirer and the target. So if the acquisition is without the consent of the enterprise being acquired, that is the target. Okay, hostile is become any document executed by acquiring enterprise conveying a decision to acquire control shall be treated as an other document. Okay. Now under SEBI regulation, there is a public announcement for listed companies. That public announcement that I am going to acquire shares, voting rights in the target company, that public announcement shall be deemed as other document. Okay. Yes or no? Speak up, guys. Yeah. You are sapping my energy by remaining quiet. Don't remain quiet. If you have doubt, ask questions also. Okay.
So can you please explain this about this public announcement with regards to this whole voting control?
In listed companies, if the acquirer or the target, or if either of them is a listed company, so it has to follow the regulations of SEBI. The regulation of SEBI is saying there is some kind of transaction taking place. It has to give a public announcement under takeover code. Okay. So what kind of acquisition is it? Whether it is of shares, voting right, or control. So that public announcement itself means an other document.
Okay.
This 5.9 I have already discussed. Okay. Series of steps and all those things. Now, green channel. Green channel means this is a very recently introduced concept. Why? See, there are certain transactions where there is neither horizontal or vertical overlap or any kind of ancillary overlaps. So what it does, it files a files an application under green channel stating that files an application stating that the application is filed under green channel, and automatically the approval is deemed. It is a deemed approval. Okay, so it's a time saving process in a transaction. Okay, however, if CCI on finding those green channel on vetting of those green channel documents find that any of these parties and their lawyers have tried to cheated them by evading filing in form 1 or form 2, it shall cancel that deemed approval and direct the parties to either file in form 1 or form 2. Understood?
Yes, sir.
Now 5, 6, this 6 one I'll take some. Failure to file. 6 very 7. 1 second. Belated notice. Okay. Okay, this is penalizing. Failure to file. This I'll take in gun jumping. The session, or if we controlled it. Who has the obligation to file notice in acquisition, in merger and amalgamation? Who has to file? Can any one of you? Sorry?
The accuser.
In which scenario? Acquisition, merger, or amalgamation?
Acquisition.
In acquisition, sir.
Acquisition. Okay. Now, in amalgamation, who has to file?
All the parties
amalgamation,
were involved in
the-
amalgamation. All the
Sorry,
companies.
come back again, both of you. What did you say?
I said in case of acquisition, acquirer shall file the notice.
Correct. In case of merger,
In case of merger,
there are
The
two companies,
merged entity.
transferor and transferee. Who will do it?
transferee,
Correct.
Both
In case of amalgamation,
a new entity which will be formed.
sorry, no, incorrect answer. I gave you one more chance. I give you one more chance. Okay. In case of merger or amalgamation, both the parties jointly, and they'll share the fees. Understood, Mr. Venkat and the person who said the new entity?
Yes, sir. Yes, sir.
Mr. Venkat?
okay, okay.
Okay.
Both the parties jointly file.
Yeah, in case of merger or amalgamation. Okay. Now I'll
All right.
told you a situation. In case of enterprise is acquired without its consent. Okay. So the entity which is being acquired without its consent. Then CCI says that the acquirer shall furnish all information as available to him as the case may be relating to enterprise being acquired. Okay. Provided that all information required to be filed relating to enterprise being acquired shall be filed within 15 days of filing of notice. In case acquirer is not in a position to extract that information, okay, relating to enterprise being acquired, the commission may direct the enterprise being acquired to furnish such information as it deem fit. Okay. So few cases commission has received on this but did not exercise it. It got resolved that the acquirer himself got all the information. Understood? Understood?
Yes, sir.
Yes, sir.
Okay. Now we go to the next page. Intra-connected transaction, I have already said. Obligation to file. Amount of fee has changed. Okay. 20 lakh and 65 lakh. Mode of payment is check. Procedure to file, you have to give a summary. What is the transaction? Name of the parties, 1A. For everyone's convenience, I am reading 1A. Name of the party, structure, nature and position of the combination, product, services, businesses of the parties in the combination, respective markets in which the parties to the combination operate. Okay, these will be filed. Okay. Either you are filing notice under regulation 5 or 8. Okay. Now, if certain documents are confidential documents, so you will write why you need those documents to be confidential documents. Okay. Say yes or no, boss.
Yes, sir.
Where is it? Okay. Okay, if all documents are in conformity, if all documents you are followed all the procedure, then it shall not be valid. When it shall not be valid? Okay, when? Unless until it is complete and in conformity with this regulation. So you have to comply with this regulation, complete on the form. Okay. Now, it can invalidate a notice when it comes to the notice that not valid, and the secretary has to convey the decision within 7 working days, provided opportunity has to be given before invalidating. Principles of natural justice. Understood, Mr. Venkat?
Yes, sir.
So CCI has to follow principles of natural justice before rejecting.
Yes, sir.
Okay.
All right, sir.
Okay. Now, provided that the period between commencement of proceedings under 2 till the decision, that period will be a stop clock. Stop clock is, that means there is certain time limit within form 1 transaction and form 2 transaction should be completed. It cannot go endlessly. Because why? Can anyone explain? Why has CCI included time clocks, time frame in its regulation? Can anyone explain it to me? Common sense, boss. Okay, another way to ask this question. Does do transaction need to be time bound, or it can happen for indefinite period of time?
It's a time bound issue. It has to be time bound.
So if it has to be time bound, then CCI assessing for competitive behavior of the parties will it be through a time bound or indefinite?
It's a time bound process.
It has to be time
Within
bound.
30 days, 30 working days, it has to be completed.
Yeah.
Oh yeah, especially for form 1.
Yes.
So that is why when these kinds of information are sought, or if there is time period to correct, that the stop clock of 30 days or 180 days to 70 days stops. Okay. Now this is important. It sends show cause notice to remove defects. Okay. Under 14.3. Okay.
Okay, sir.
Yes, sir.
Okay. Next. Now, if the parties fail to remove the defect, okay, so that notice will not be treated as a valid notice. Then you have to file it fresh.
Yes, sir.
Yeah. What? if there are defects, if you do not rectify the defect in a certain period of time, what will happen?
Will be rejected.
You have to file it fresh.
Yes.
Yes, sir.
Mr.
There will be a
Venkat,
lapse of
understood?
time.
Sorry.
Lapse of time will lead
Yeah.
to a cancellation and fresh process
Refiling.
to be begun.
Refiling.
Yes. Understood, sir.
Understood. Now computation of time. Now if there are any changes, Rishi is here. I admitted him. Is Rishi here? Who is from Lawseco?
Yes, sir. This is Yashasvi today replacing Rishi.
Okay, can you share the exercise? He has shared me. Let me open my WhatsApp if it is there or not. He has shared me my WhatsApp exercise. Please, all of the guys, all of you who have attended this, do take up the exercise. So let me take you through the regulations. I have taken you to regulation till 15. Okay. Now I will take you through. Who is asking my WhatsApp number, boss? Venkat. Okay. Now,
I have the exercise. Can I share it in the chat?
yeah, share it, boss.
Sure.
You can use it because I believe I got the exercise for the next class. So you can do a screen sharing. Okay, you did shared it. 1 second. Let me open it. Okay. Gun jumping. No, this is gun jumping and mitigating factor. This is not the exercise. I have shared the exercise. Exercise has been previously shared, if I'm correct.
Sorry, sir. Let me get back with the updated.
Meanwhile, I'll teach them something more interesting. So, can everyone see Competition Act?
Yes, sir.
Venkat, Dr. Mustafa.
Sir, yes, sir. We are seeing one page, but
Which is saying? Okay.
yes.
Okay. Now, I taught you regulation in the reverse manner so that your brain get rewired to understand. This is, no person or enterprise shall enter into a combination which causes or likely to cause AAC in a competition within the relevant market in India, and such a combination shall be void. Okay. So, no person or enterprise shall enter into a combination which causes or likely to cause AAC within relevant market, and such a combination shall be void. That means any kind of transaction which is relating in anti-competitive, okay, cannot enter. For that, subject to any person who or which proposes to enter into combination shall give notice to the commission in the form, understood, form 1 and form 2. Yes, either in form 1 or form 2. Yes or no?
Yes, sir.
Okay.
Yes, sir.
And the fee I told you, either 20 lakhs
20
or
lakhs or
65 lakhs. Or disclosing the details about what? Approval, okay, by the board, approval of merger by the board of directors, or execution of an agreement or other document. I told you what is other. Okay. No combination. See, the word combination means under Competition Act is basically in simple term, it is a transaction. So, however, under Competition Act, the word combination is used. So let me read. No transaction shall come into effect 210 days from the date of filing. Okay. Till the CCI passes an order of approval under section 1, approval, rejection or modification. Okay. Okay.
Yes, sir.
Okay. The commission shall, after receipt of notice, it has to be dealt under section 2931. Okay. Now, there is Form 3. This Form 3 means if there is a share subscription, financing facility, or acquisition by a public financial institution, foreign FII, bank, venture capital fund, okay, pursuant to a covenant of a loan agreement or an investment agreement. In those scenarios, what has to be done? You have to file with the CCI within 7 days when the transaction is complete. Okay. Where you have to give details of control, circumstances for exercising of such control, consequence of default arising out of such loan agreement or investment agreement. Okay. Understood? Yes or no?
Yes.
Now I will take back to you the regulations once more. Sorry. Can you see the regulation? Or you are seeing the act only?
Regulations.
Hmm?
We can see the regulations.
Filing of details of acquisition. See, the regulation giving details, how it has to pay. The details of acquisition by PFI, FII, bank, venture capital, pursuant to a loan shall be filed without any fee. No fee is required in Form 3. Understand this?
Sir, what is Form 3? Earlier you taught about
Form
Form
3.
1,
Form 3 is for those filing where acquisition is done by public financial institution, FII, bank, or venture capital fund, covenant to a loan or an investment agreement. Okay, then you will file Form 3. Okay, now where details of, even if the commission may admit the details, time is of no significance, time is of little significance. Okay, 7 days is mentioned in the act, but it says that, okay, it said 10 days, 15 days, but it can be considered. There is no penalty kind of a thing. Okay. Okay.
Yes, sir.
Okay. Fine. Now, that would wind up your control. Okay. In the next class, I will be taking gun jumping. Are you there, guys?
Yes, sir.
In the next class, 1 second, let me share the page. Competition Act. Gun jumping. For gun jumping, please read. I'm sharing you the particular sections. Please come and read, please. It will be easier for you to understand. Commission. The commission may, upon its own knowledge or information relating to acquisition under section 5, inquire whether combination has caused or likely to cause. The commission shall not initiate an inquiry after expiry of one year. Say there's a transaction which is already consummated. Now CCI looks into it. It says, okay, boss, they did not sought a CCI clearance. Irrespective, they meet the thresholds. Okay. So it can only look into transactions and initiate an inquiry which is 1 year back. Okay, not more than that. Okay. So gun jumping is not defined in the Competition Act. Gun jumping has been evolved through practice. Okay. Now we come back on the receipt of a notice. What does it require? CCI inquires that notice. Okay. How do you investigate? 30 days. Okay. When the CCI prima facie opinion. Okay. Phase 1 and phase 2. Phase 1, generally most of the cases are completed in phase 1, 95% cases. Only phase 2 is required. So forms an opinion that AEC, okay, it shall issue a show cause notice, calling them to respond within 30 days. Whenever CCI issues a show cause notice. Okay. After the commission may call for DG report, it never happened. Whenever I was there for 5.5 years, it never happened. Okay. Commission may form prima facie opinion.
So DG means
Director
means
General.
what? Okay.
Director General. Investigation. See what happens in these quasi bodies. There is an investigating body. Okay. With these regulators. So it's investigated anti-competitive aspects. Okay. Okay. Any doubt? Any doubt, anyone in this class? Say yes or no,
Fine,
boss.
fine, sir, fine.
Okay, in the next class, I'll be taking gun jumping. So you please read gun jumping. I'll be taking case laws, how it evolved and how it came in India. Actually, the gun jumping is only codified in CADE. CADE is CADE in Brazil Competition Authority. Nowhere it is codified. Okay. Okay, who is the course anchor?
Yes, sir.
I am calling off this class today. Anyone has any doubt so far?
So my one doubt is other document means when the hostile acquirer has acquired shares of the
One
original
second,
target
I'll take you
company
to, I'll
and
take you to the regulation straightforward. Other document, 1 second. Can you see this page?
one second.
No, sir, no.
Now,
Yes, now, yes, speaking.
Yes, sir.
See other document, the reference to other document under clause B of section 6(2). Okay, of that mean binding document. Okay, conveying an agreement. What is the binding of conveying an agreement? Decision to acquire control, shares, voting rights or assets, provided if the consent public announcement is a deemed other document. Understood, Mr. Venkat?
Yes, sir.
If acquisition is without the consent of the party being acquired. Okay. Okay,
Yes,
any
sir.
document executed by the acquirer is also decision to acquire is also another document. Okay.
Oh, yes, sir. Yes, sir.
Understood? Any doubt?
Yes, sir. Yes, sir. Doubt cleared, sir. Thank you, sir.
Okay. Okay, guys. Okay, guys, I'm signing off. Meet you next week. And hopefully all
Thank
of
you,
you
sir.
please read that gun jumping section.